Greetings, everyone. This is Module 12 for our course IT248, Information Privacy Regulation and Policy. And the lecture for Module 12 is principally based on Chapter 12, which is from our required reference book for this course, Legal and Privacy Issues in Information Security. I've added information, obviously, in some videos and added some information on doxing that I thought was an important privacy issue that wasn't really addressed in the book in this chapter either. So with that, let's begin. We'll cover a number of issues in this module, but we'll talk about the difference between criminal law and tort law, cybercrime in specific, tort law, which is civil law essentially, and some other issues with cyberspace or cyber squatting. And there's an important law called Computer Fraud and Abuse Act, which principally focuses on unauthorized access to inflict damage, and not so much on privacy, but we'll go through that law in some detail. So the Computer Fraud and Abuse Act looks to protect computers. And what computers does it protect? Protected computers. The definition of protected computers principally is computers that are connected to the internet. The law was initially focusing on federal, financial, and national defense computers, but essentially it's applied now to really sort of any computer attached to the internet that can be hacked. And again, this is not as much focused on privacy as it is unauthorized access. Even pre-attack recognizance is prohibited by this law as well. Obtaining information from a protected computer illegally or in unauthorized fashion is a problem. If the intent is to defraud or to create a distributed denial of service or delete data, threatening or damaging a system, trafficking in protected computer passwords is also a problem. In this case, it might be related to privacy here, traffic in protected computer passwords, and espionage. So it's essentially a law really designed to have a club against individuals who attempt to through reconnaissance or actually attack a system to either defraud it or steal passwords to traffic and sell, or to do in some way damage or disrupt a system. And again, it's really applies to any computer connected to the internet. And there's a video here you can watch. You could go to the PDF. You could just cut and paste, this URL and watch some more information about this particular law. You're probably aware that there are two types of wrongful conduct that can be illegal. A minor crime is a misdemeanor. A more serious crime is a felony. So you've probably heard those terms in the past. So here are some of the elements of a crime. Mens rea, which means guilty mind. So that means that you have intent to hurt someone. You have a criminal intent. There is some sort of criminal intent that makes this not accidental. This makes this a criminal act. You also have to have a guilty act. The actions must be voluntary. So that's called actus reus, a guilty act. The actions must be voluntary. You've done it, intentionally. Also, a wrongful act can also include the failure to act when there is a duty to do so. So you have an obligation to do something to maybe help someone, or prevent something, or prevent a serious crime, and you did not. That could be potentially a wrongful act and possibly a criminal act as well. If you've watched any law enforcement, police type TV show, you've probably seen the steps of a criminal procedure. Enforcement agency, the police or the FBI, or some enforcement agencies involved, they do an investigation. The prosecutor reviews the case to see if there's something there that's really worthwhile and to prosecute, that there's a case that you could probably convict someone of. Citizens have a right to a grand jury for an indictment. If they get indicted, they go to trial next, and then they can have a trial by jury, which then decides the outcome. And obviously, there could be a hung jury. It also ends if a jury cannot reach a decision. That's called a hung jury, and the case is closed because no one can really conclusively decide on the case. So the case is sort of closed at that point. There are 4 ways that an electronic device or a computer can be used to commit a crime, for someone to commit a crime with, and these are the 4 roles. Committing a crime is hacking. That's actively hacking. You're committing a crime. Phishing, that's intent to commit a crime. You're trying to facilitate a crime. Targeting, distributed denial of service. You may not have brought a server down. You may not have had any impact, but you targeted that server, and that's a crime for targeting it. And then, of course, logs are very important. Logs can be a witness to a crime, and that's the fourth way in which a computer could be involved in a criminal activity. All right, the next few slides go through specific laws that are involved with cybercrime. The first one, the first one here is Theft and Assumption Deterrence Act, and this essentially makes identity theft a federal crime. There's also the Wiretap Act that was passed in 1968. It basically requires a warrant to wiretap and listen to a phone call. As we said earlier, your metadata you don't own. The government does not need a warrant to collect your metadata. But to listen to a conversation on a phone, they have to have a warrant, and that's required by the Wiretap Act. That was expanded to include all electronic communications in 1986 with the Electronics Communications and Privacy Act. ECPA governs access to stored information, all electronic information. And we talked about this in Module 2 on slide 14 when I created that mosaic, that spreadsheet of all of the different laws that protect us or are supposed to protect us from our government spying on us. And as you may recall in Module 2, it's very complicated, and I put that in a couple of slides where I tried to document all of the different laws, and from the Patriot Act, the Freedom Act, FISA, and the FISA amendments. It gets pretty complicated if you go back and look at Module 2 of the couple of slides there on that. And one of the first slide on it, I do call it, it's literally a mosaic. It's a complex mosaic of laws that overlap, and we really need one universal law to protect privacy of the citizens. And we'll talk more about ECPA also in Module 15 as well. So these three, identity theft is illegal, wiretapping is illegal without a warrant, and electronic communications governs all stored electronic communications. So it's a bit broader, more broad than the Wiretap Act. A few more laws involved with cybercrime is the CAN spam, which is probably not a great acronym because you cannot spam, but it's an acronym for controlled assault of non-solicited pornography and marketing. Passed in 2003, it makes spamming illegal. Spoofing IP addresses or URLs are also illegal. And in fact, there's a lot of analysis out there that says over 50% of the emails transmitted over the internet are still spam. But of course, if you're insistent on it, and persistent, you could be prosecuted if you really creating a problem. If you create problems for individuals and flooding email boxes, etc. There's also the Anti-Cybersquatting Consumer Protection Act, and what this does is, and this is a big problem actually. If you look at a lot of the attacks that are going on for the last several years, many of it have to do with cybersquatting. So what cybersquatting is, someone will take a legitimate URL, a legitimate URL address, like let's take Amazon.com, and register a name that's similar to Amazon.com but a little bit different. Or they may use the @ sign for an A and put the rest of the spelling of Amazon just with MAZON. However they do this a number of different ways. They create a similar name, and the reason they create a similar name that is to confuse people. So if they go through a phishing exercise and they get someone to click on a link or click on some malware that connects them to the hacker's website will have a very similar URL address. So it might confuse the target of the attack, the potential victim, in that looking at it quickly or not looking at it too closely, they may not realize that the spelling is a little bit different. And they may go on and put their credentials in, their ID and their password. It might be the bank that's spelled a little bit differently, or there's an extra or term that's added or left out. So that's also illegal. And there's a lot of cyber squatting that happens. I mean, you see this if I get alerts from a few different locations, a few different cyber anti-malware companies, including IBM's systems, and I see this almost every week. There's a number of different cyber squatting campaigns that are caught, and it's illegal to do this because people realize you're trying to fool people into doing some create some transactions or some activity on that similar sounding URL. The information on this slide might be sort of self-evident, that it's illegal to transmit malware, viruses, worms, any sort of software that can damage a computer. That's illegal to transmit that over the internet, or obviously attack a server with that. And cyberstalking is also illegal. You're trying to harass or stalk someone with the intent of harassing them or creating a crime, or attacking that person in any way. So these are the three laws that are involved. There's a harassment act, there's an anti-stalking act, and Interstate Communications Act also can be used as leverage to prosecute individuals who do these two activities of transmitting malware or cyberstalking. I think these are pretty self-evident. I think most people are aware of this. All right, we may have mentioned this earlier, but there's criminal law and there's civil law. And civil law is really tort law. So tort law is part of civil law, and this is when someone is being prosecuted for harming someone. It's a wrongful act or something that's harmful, but it's not necessarily a criminal act that you could be prosecuted and go to jail. So the classic example that's used often is O.J. Simpson. He won the criminal case, and he was acquitted of the murder in a criminal trial and did not go to jail. He was not prosecuted. He was prosecuted, but he was not convicted. But he lost a civil case from the families that sued for loss of income and loss of their family members, and had to pay very costly damages to the families of these two individuals. So it's really an unusual case because it was a very famous case, obviously, where the defendant won the criminal case but lost the civil case, lost the tort case, and had to pay very significantly with his own funds to compensate for the loss of those two individuals' lives. Tort law has three levels of severity, and I put a little arrow here to sort of indicate that as you move from left to right, it gets worse. The significance of the case looks worse and worse for the person who's being accused of the infraction. So there's the concept of strict liability. You're responsible even if no harm to another person was intended. So accidental, but you still may be liable for some financial penalties. Negligence, obviously, you're looking at some more severe penalties where you didn't take due care. You were negligent, and something negative happened and harmful happened to this other person who is now suing you because of your negligence. And then there's sort of intentional harm. At this point, you're bridging the gap to a crime. You're taking a civil case and turning that or moving that into a criminal case where it shares some elements of a crime, of criminal activity. And at that point, you could be prosecuted criminally. Civil procedure. So a few slides earlier, we talked about criminal procedure, where the enforcement agency gets involved, the police or the FBI, they do an investigation. They look to indict someone potentially with the jury. And it's a whole different process on that other slide. The civil procedure is very different. There is no law enforcement. You feel you've been harmed, you've been hurt, either physically or financially. And as a plaintiff, you file a complaint with a court. So there's no police, there's no FBI, there's no enforcement agency that's involved. And then the court delivers the complaint and a summons to the defendant, who's the person being accused of the harmful act. The defendant must respond to the complaint, admit or deny the claims, or just proceed. That just proceeds to the next process of a discovery process. Discovery process is where both the lawyers, both attorneys on the plaintiff and the defendant side examine each other's evidence. And this is where it gets interesting, because sometimes there are things that come out not related to the case that may be embarrassing or could really uncover another, whether a tort case or another civil case or a criminal case. So the discovery process is once in a while comes up in the news as a process in which new cases appear or new problems appear, or just embarrassing information is revealed as a result of the discovery process. And then once the information is exchanged between the lawyers for the defendant and the plaintiff, then the parties settle their lawsuits in trial, or they may settle out of court, which happens, fairly often in civil cases as well. All right. So what are the common reasons that there are tort law cases, civil cases, lawsuits involved with activities on the internet in cyberspace, let's say, right? So things on the internet that cause civil lawsuits, not criminal lawsuits, but civil lawsuits. So libel, a written statement that's defamatory or makes someone look villainous, that's libel. Slander is a little different. It's the same color and same overtones, but it's oral. So slander is oral, libel is written. But the concept is that something has been written or said about you that's defamatory, that makes you look villainous, that creates some negative and inaccurate, completely inaccurate description of your persona, your personality, or your activities. Another common violation is intellectual property, IP, intellectual property lawsuits, and this is very common with software. If you look online, you'll see at any one point in time there are well-known dozens of cases going on at any one point in time where Apple is suing Google, or IBM is suing someone else, or someone's suing Apple, or suing IBM, so that these software companies, it's pretty complex in terms of obviously some of the functionality, and when there is some overlap, someone feels that they've stolen some copyrighted material or some information or design or process that was copyrighted. It doesn't have to be a program. It could be a process that was copyrighted. That was patented, that someone felt was a breach of their intellectual property. Intellectual property could be a patent, or it could be a copyright as well. It could be a music copyright. It could be a written copyright. It could be either one. Intellectual property is not. I want to be clear. It's not specifically involved with patents, but it could be copyrights as well. Another common lawsuit is emotional distress. One party sues another party feeling that what was said about them is not only wrong, but it created an emotional distress. So a libel or a slander could create a financial problem for you. It could hurt your brand. It could do things to you financially, but there's also emotional distress. And it could also be part of a lawsuit, or a lawsuit in and of itself, just relying on emotional distress. Trespass, pre-attack reconnaissance. When you use certain reconnaissance tools like Nmap or ZenMap that actively go and look for open ports, that's trespassing. That's actually illegal to do that. Spam that invade your inbox may slow your servers down. These can be considered trespassing and can be cause for a civil lawsuit. And of course, depending on the characteristics of it, if the reconnaissance is shown to be part of an active plan to create a crime, or if you're if you're spamming with the intent to have sort of a distributed denial of service, where you're trying to crash a server, this tort civil case could turn into a criminal case. And privacy violations. Portrayal and false light is the actual legal term for someone saying something, portraying you as a racist or a villain in some way, or negatively. So it goes back to defamatory. It's very much related to that. Or disclosing private information. So I felt this last one actually sort of begged the question of doxing. So I added a slide just to follow this one about doxing in particular, because it is a problem. It can be illegal in certain situations. So these are the most common activities that happen on the internet or in cyberspace that cause civil lawsuits. Well, we would be remiss if we didn't talk about doxing, because that happens a lot on the internet. You hear about it in the news quite a lot. So doxing is the act of publishing someone's personal information, their address, where they live, their phone number, where they work, putting it online without someone's consent. Now, whether doxing is legal depends on how it was obtained. Doxing is usually legal, but it could be considered a crime if the information was obtained unlawfully through some illegal hack, or it was motivated by cyberbullying or harassment. So there's a thin line there, obviously, between doxing someone with the intent to harass them. But this is one of those areas that I think we do need some more specificity and strengthening in the laws, because people are doxed. We've had Supreme Court justices doxed, their home addresses doxed, and I'm sure it wasn't doxed to send them fan mail. They were being doxed to harass them and create a problem, during important cases that are under review. So I think the laws here probably need to be strengthened a bit. Actually, that's probably not a good example, because there are laws that protect judges during deliberations when they're deliberating upon a ruling that is specifically illegal. There are laws specific to that. So that's probably not a great example to use a judge. But take an executive of a company to put their home address and where they work, information about their hours, where they're working, or how they travel, what their travel plans are. If that information is sort of in the public domain and on the internet, and someone docks it out there for others to see, again, if it was obtained legally from public sources, it might be legal, but it could be considered cyberbullying or harassment if you could prove that piece of it, that component. And it's certainly illegal doxing if the information was hacked or obtained illegally some way. And to give you other clarification, I have a little 6-minute video on it. You should look at that. And again, if you look at the PDF, you can just copy and paste the URL and not have to type it out and watch it. I think it's an interesting video because it is a problem, and I do think that the laws to protect us against doxing are probably not defined enough and not specific and not definitive enough. But what I said earlier about protesting and demonstrating in front of a judge's home or where they work, in front of the courthouse, while they're going through deliberations, there is a federal law against that already. So I don't want to confuse the issue. That there is something that protects our judges as they're deciding a case, not to be harassed or unduly influenced through harassment, or threats. So that's sort of a different topic. So here are some examples of cyberspace or internet lawsuits that are sort of interesting to review. A company named Phoenix Avatar, they obviously had some spamming activity that was considered illegal by the FTC, the Federal Trade Commission, or the FTC Act of the Federal Trade Commission. And the individual involved with spamming, Daniel Yin, obviously the courts must have felt he was criminally involved in this spamming in a very malicious way, and he was sentenced to 3 years in federal prison. So it's not just financial penalties involved here in these criminal cases sometimes. And Phoenix Avatar paid $20,000 in a settlement, I imagine, to the FTC. I'm not too sure of that case, but you could just be cautioned that spamming with the intent to do some damage can put you in jail as well. It's a criminal case, not just a civil case. And then there's also defamation, which is pretty common. And on Module 2, Slide 12, we had some details about Vanna White and Nicholas Sandman. Nicholas Sandman won many, many millions of dollars in defamation against him, against CNN and a number of other outlets and media outlets. And then there's, of course, Kyle Rittenhouse has several active lawsuits. I don't know if they've been resolved or not. One actually against the President of the United States, Joe Biden, who I guess incorrectly repeated information from some of these media media firms saying that Kyle was a white supremacist and he was part of some group and he wasn't. And so he's got a defamation lawsuit worth a lot of money against several media companies and the federal government as well. So these are all sort of interesting cases about cyberspace legal infractions. This concludes the lecture on this particular module covering this chapter 12 in the book, as well as other related topics. So if you have any questions, as usual, let me know during class, and we can review and have a conversation about what your thoughts or questions may be.